Non-economic loss and economic loss. What's the difference? Hi, my name is Bunner and I break down personal injury law into plain English so you better understand your rights and entitlements. So when it comes to personal injury claims, you may hear people talking about non-economic loss and economic loss. So I want to quickly talk through what the differences are in those two heads of damages. Dealing with non-economic loss first. This is generally what is known as pain and suffering. So it's a portion of a most extreme case. So we often look at where you sit on a scale to a most extreme case, such as paraplegia or total blindness. And the claim is meant to factor in the way in which the injury has impacted your life. So your recreational activities, family, lifestyle, sporting, your day-to-day activities and how they've been impacted by the injury. It can also factor in your age and what you would have gone on to do but for the injury. It can be really subjective. So what I often say to people is, say if you lost a finger amputation, that might be very different to someone that may have been a concert pianist, for example, and they've lost a finger compared to someone that it may be on their non-dominant hand. Now, the second aspect is economic loss, and this really looks at both past economic loss and future economic loss. When we look at the past and it's time to assess a claim, that can often be just a matter of mathematics. So we look at what you were earning and what you've then earned from the time of the injury to that point in time. We also consider a loss of superannuation as well on that past claim. Where things get a little bit more tricky is looking at future economic loss. Now, a future economic loss claim, we're really looking at what you were earning, what you would have gone on to earn, how long you would have worked, and then we need to compare that to what your capacity is now to earn on the open labour market. We can look at comparable earnings in many ways. So we might say, well, look, had you stayed employed in that role, we can now see wage material and that's what people are earning in that role and that's what you would have gone to earn. Or sometimes there's an argument that you would have gone on to do more study, you had already commenced a course to better your skills and get a promotion. And so in that scenario, we're looking at those comparable earnings of that new role that you would have gone on to do. Another big factor is how long you would have gone on to work for. So depending on age, we generally look at ordinary retirement age, around 67 years of age, but sometimes there can be some questions around what your plans would have been but for the injury. And then of course we have superannuation. So we claim your loss of superannuation on top of those future earning. But if you have any questions about economic loss or non-economic loss or personal injury claim in general, please reach out to the team at Bunner Legal. We're here to help.